in the last Court of Appeals decision, the court suggested that maybe a particular provision of a federal law that was meant to encourage the FCC from forbearing from regulating could actually be considered a positive grant of authority for the Commission to actually preempt states' laws which either prohibit or require, as North Carolina's does, that if they're going to compete, that they do it on a level playing field basis with private industry. Competing against the government, as anyone might recognize, is a little more complex as competing against another marketplace competitor. And so it'll be interesting. The chairman of the FCC has indicated his desire to consider preempting state laws, although he hasn't floated it in writing in a way that can be analyzed by lawyers and analysts. I suppose that may be coming in the near future, but suffice it to say that there will be a serious legal question about whether that actually could be done. I mean, it's not very hard to look at that and understand. You have really two issues when you have a preemption question. The first is the constitutional question of whether the particular power has been given to the government agency to preempt a state's laws. And here, I think the state's interest in protecting the financial health of its municipalities would be at a fairly high level. We've had some examples in North Carolina already of problems that were part of the moving force in the legislature to do something about this, on top of the fact that our customary public policy, the Umstead Act and other public policies in North Carolina have long favored not having the government compete with private industry. Government usually does things that are core to government service and that are, monopolies that the government itself can own and operate more efficiently, like water service and things of that nature. But here it'll be interesting to see whether the Commission, A, goes ahead and tries to do this, and B, if they do, whether a reviewing court would agree that from a federalism standpoint it doesn't invade the legitimate province of the state's sovereignty in making financial decisions for its municipalities, because of course cities and counties in North Carolina are creatures of the state. There's nothing that says they exist or have any independent power on their own other than what the state legislature has given them. So when the state legislature makes a decision to put in a level playing field law into effect, such as it did here in North Carolina, we would argue that that would be entitled to substantial weight in any preemption analysis.